Do you want to apply for permanent residence while staying in the United States? Well, I have a solution for you. I'm U.S. immigration attorney Sharifa Tharpe. I help clients to get their green cards and status in the United States. I also come on here, the immigration attorney, to give you great information that will empower you through your immigration journey. Let's get started. All right. So the first what I want to talk to you about is the adjustment of status. So adjustment of status is the way that you're going to stay in the United States and apply for permanent residence. The great thing about adjustment of status is that you're able to apply for a work permit and even a travel document that can allow you to move back and forth if necessary. Now, you will definitely still have to qualify for this by meeting specific criteria. I like to say not everyone who qualifies for permanent residence is going to qualify for adjustment of status. So you have to be very careful with that. That's where it's very important to speak with an immigration attorney such as myself to make sure that this is the right process for you. Let's get started though. Are you the person who can qualify to stay in the United States and apply for permanent residence? Keep in mind that this may also include individuals who don't have their status. Let's get started. So who qualifies for family-based adjustment of status? This process is going to be based on family relationships. And remember what I said previously, it also includes individuals who may not necessarily have their current status here in the United States, but you can still apply for it. So here's a list of those family relationships. The first is you may qualify if you're maintaining legal status in the United States, you have an approved I-130 petition, your priority date is current. So the way that you check your priority date is that it's going to be that received date on your I-130 receipt notice. And you can look at the National Visa Bulletin. On that website, you're going to see a date listed. And if it says C, that means that it's current. So C means current, that you have a current priority date. Also, if you don't see the C, but you see a specific date and your date, it has already passed, your date is before that date that is showing up, that also means that you have a current priority date and you may be able to apply. Now, also, you have to keep in mind that if you have other disqualifying factors going on, you need to be aware of that so that you understand how to approach your adjustment of status process. When I say other disqualifying factors, you want to make sure that you don't have any criminal issues, any accrued unlawful presence, and also unauthorized employment. If you do, then you're going to want to definitely, regardless, you need to speak with a U.S. immigration attorney, such as myself. I help my clients through these issues, but if you have these issues, make sure you make it a priority because these can complicate your case, maybe even disqualify you. So you want to make sure before you submit any applications that you actually qualify for this benefit. Now, if you qualify for this, you could apply for you'd submit the adjustment of status application, but you could qualify for your work permit and other benefits. And you would also have the benefit and the advantage of staying with family, starting your life in the United States, or just getting it back on track. Now, I want to address, which I have been saying, teasing before, that if you're out of status, you could qualify based on family relationships. And so if you're out of status, but you're the immediate relative of a US citizen, then even if you've overstayed your visa or you've overstayed your permission to be here, you could qualify for this still. And this would allow you to move ahead, fix your status, get your work permit and your travel document. Now, keep in mind, it is limited in a case like this, it's limited to immediate relatives of US citizens, and that doesn't mean every relative of a US citizen. So that's a big misconception that I want to make sure you understand here. It only includes the spouse of a US citizen, the parent of a US citizen, and that US citizen is 21 and up, or you're the son or daughter under 21 and unmarried. You have to be unmarried to qualify for this. Unmarried means that you are currently not married. And if you, for example, if you got married and then you got divorced, you're considered to be unmarried. Now, there are other situations where you could apply based on a family relationship, but your family member may not be the one petitioning for you. And this is what I refer to as the VAWA. So if you have been granted VAWA, so VAWA applicants are those who are being mistreated by a US citizen or a legal permanent resident spouse, a parent, if you're under 21, under 25 in some cases, or by a US citizen, son or daughter who's 21 and up. If mistreatment is broadly defined, so mistreatment and extreme cruelty could involve verbal, mental, emotional, financial, and also physical. But keep in mind, you don't have to experience physical harm or injury or mistreatment to be able to get this VAWA status. But first, you could apply for VAWA status, which would enable you to get your work permit. You would be able to get your status here in the United States. And then from there, you could adjust status to permanent residence. And this all is done without involving the abusive relative or the relative that's subjecting you to extreme cruelty. So it's an important form of immigration relief to take in mind when you don't necessarily have a good relationship with your relative, but they are mistreating you, and you could apply on that basis. There are so many situations, and I represent so many clients that go through this, and they think that they don't have a path to fix their status in the United States because their relative is refusing to apply for them. But I'm here to tell you that that can be done. Now, there's also, if you have the T or U status. Now, this is not based on family relationships, but I did want to mention it just because if you are here without a family connection, but you receive the T or U status, you could adjust status. And if your relatives got the T status or the U status with you, they could adjust status. Now, T is for victims of trafficking, and the U is for victims of qualifying crimes. And then last is the asylum. That is also important to know, that if you've had a history of being without status, but you received asylum, after 1 year of having asylum, you could do adjustment of status. But keep in mind that the T, the U, the asylum are humanitarian based, not family based. But I wanted to bring that to your attention. I'll definitely do videos about these. Now, I want to talk about what comes next after you've determined that you qualify. Then it's to actually apply. One thing I like to say is that preparing your application is the most essential part of this, because if you don't prepare a great application, then further down the line, it may create complications. So make sure that you get the legal representation and assistance you need to move forward in your case. And that's going to increase your ability to succeed in your process. Now, the list of forms here it's an extensive list. And so first, your relative will have to file if you're directly applying, so your spouse, your parent, or your son or daughter is applying for you, they're going to submit concurrently or separately, depends on how you did this to begin with. But first is the I-130 petition. That has to be pending at some point in the process. Then, and this is called the petition for the alien relative. Then you're going to submit the adjustment of status application. It can either be filed with the I-130 or with the I-130 receipt notice. You also have to submit what's called an affidavit of support. Affidavit of support is it's a document, it's a contract with the government that says that your US citizen relative or will be able to support you financially. And so it shows, you'll have to show evidence that you, if you're the petitioner or your relative, can meet the income requirements to be able to support you. If you go to the uscis.gov, you'll be able to find the income requirements on the I-864P form. Now, there are different types of I-864 forms. So generally, it's usually the I-864 affidavit of support. If a household member is joining the sponsor, the petitioner, that's the US or resident family member, in joining their income in the household, they would have to complete what's called an I-864A form. So keep that in mind, that there may be different forms just based on different types of relationships. The affidavit of support can be one of those types of applications that delays your process. It can even lead to a denial. So it is very important that you understand it, and it is very technical. All the more why you should make sure you seek representation through your process. Now, if you want a work permit while you're waiting for your process to be completed, you'll submit the application for employment authorization. And if you want a travel document, I always tell my clients it doesn't hurt to have it in case you need to leave the United States quickly for an emergency. You would submit what's called the I-131 application for travel document. Now, this is if you have a US citizen or resident relative who's directly petitioning for you. But remember, previously I talked about VAWA. That's the confidential process where if you have a family relationship or connection to a US citizen or legal permanent resident spouse, a parent if you're under 21, under 25 in some cases, or a US citizen son or daughter who's 21 and up, but they're mistreating you, and you want to apply for relief based on the mistreatment, you won't have to, so you wouldn't submit an I-130, but it would be what's called the I-360 form. And this is because you'll be signing your own petition. You will be the petitioner. That's why they call it petitioner. You'll be the self-petitioner in the self-petitioning process, because you are not involving that relative who's mistreating you. Of course, this process where you're submitting the I-360 form based on the mistreatment, you'll have to show the evidence of the mistreatment. That's what I help my clients to do. And you will file this in some cases along with the adjustment of status or after your VAWA, the I-360 has been approved. Then you would be submitting the I-765, the application for employment authorization, along with your I-360 and adjustment of status application, and then the I-131 application for travel document. It's important to get guidance on this, just because the different forms may be applicable at different points in your VAWA process. Now, that is what I have for you based on this. So based on the adjustment of status process, after you filed everything, of course, keep in mind that you do have applicable fees. Fees apply to the adjustment of status. There are certain instances, for example, in VAWA where you could request a fee waiver, but you also have to be prepared for that. Once you've properly submitted the application with the evidence, the fees, and the relevant, correct, up-to-date forms, then you're going to wait for the next step, which is usually the biometrics appointment. That's your fingerprinting appointment. It's coming about 3 weeks to even a few months after you file. I'm seeing more on the 3 to 4 week timeline now. During COVID, it was much worse. And some service areas may still be backed up. But you could expect the fingerprinting biometrics appointment first. This is a very simple, quick appointment. You should not be intimidated or nervous about it at all. It's literally 5 minutes. I mean, you'll probably spend most of your time waiting for your turn to do your fingerprinting, to sign, and take your picture. After the biometrics, then you could expect the work permit. Now, unfortunately, work permits are backed up right now. There is a way to request that your work permit gets expedited under certain very specific circumstances. Right now, that does include if you're a healthcare worker, just because the situation is so dire with the pandemic right now. So if you're a healthcare worker, that means in any capacity, you need to make sure you apply to get it expedited. I also work with my clients and contact the USCIS to get their cases expedited if they're a healthcare worker. So the work permit is taking anywhere from 4 months to 11 months. After you've received your work permit, it gives you some reassurance and stability while you wait. And so you can work. So that work permit does not limit what you do for work as long as it's legal. Now, once you have your work permit, my clients tend to relax a little but then we wait. And we wait for the next thing, which is usually the interview. In some cases, the interview may even come before the work permit. So always be prepared. Then be prepared for your interview. Start thinking about your interview. That's also where it's very important to get legal representation, because I help my clients to prepare for their interview, especially where there are some complex issues going on in their case. So that's what I have for you today. I hope it was helpful. Make sure you make sure you subscribe so that I can continue to give you great content that will empower you through this process. Have a good one.